Zoom. It was a conference call system that other people could call into. And we had you know, we went through a couple practice meetings so that they could see how it worked. And it really, I think, alleviated a lot of concern that way. So if there's particular, if someone who asked this has particular circumstances that weren't addressed here, I'm happy to follow up on that.
Well, thank you. I think that's a big part of it is the technology and the fear of, well, maybe not having the device to do it or not understanding how to do it. And and I mean, to be honest with you, when I first started with Zoom, I was a little like, not quite sure about this. I mean, I could do Skype. I've been doing Skype for years, but this was new. And so, you know, it's something to think about. And so, yeah.
Yeah. One of my first township board meetings I did, I'll never forget. It was like, you look at the screen and everyone was a little bit older, and I was looking at like bangs and just tops of heads and like under chins, and then sometimes you couldn't even see the person. So I think, you know, I think people have gotten a little bit more used to it. So hopefully it'll, you know, resolve itself.
Right, and it's not going away. I mean, especially regarding the Open Meetings Act. In my first, when I sent the questions to Ann on Friday, a lot of things had not happened yet, especially with the Supreme Court and ruling against Governor Whitmer. But one other thing I had asked about was the Open Meetings Act, and do you think libraries will still continue to be able to meet with, sorry, one more person to admit, this way once COVID's done, and do you think this will be a change? And then read about State Bill 1108 and House Bill 6207, which would basically do just that. Do you want to elaborate on that a little bit, Ann?
Yeah, I want to start out by saying, and I'm gonna do a disclaimer here because I have to. My legal counsel at the firm tells me I have to. That this is not to be legal advice. This is just informational only. But I do give, because I want to give you my personal opinion on the Open Meetings Act issue right now. I think there's some associations that have come out and said you can't meet virtually now because the EO was struck down. I think there's some, I've seen news articles where some cities are coming out and saying we can't meet virtually now because the EO was struck down. I don't agree with that. I think there's plenty of support within the Open Meetings Act itself that would suggest that you can still meet virtually. And so that's the way I'm recommending clients to go. If your board has, wants more information as to why that is, I'm happy to talk with people individually. But as an overall thought, I'm comfortable with continuing with Zoom meetings, even if the bills aren't passed. But those bills, what they do is they basically solidify, there's lots of issues. You guys heard about the Supreme Court opinion that was issued that basically struck down the governor's authority to issue the executive orders after, I think, April 30th of this year. So what it does is it essentially takes what she did and put into an executive order actually into the Open Meetings Act. So it will specifically allow people to attend by Zoom, which I think is, I'm going to pull it up. What was the Senate bill again? I'm going to list
Senate Bill 1108.
Senate Bill 1108. So what they did a while ago was they introduced and they actually passed specific remote meeting participation. You can specifically participate remotely if you're in the military. And so what the bill does is it adds the additional ability to meet remotely if you've got a medical condition or there's a statewide or locally declared state of emergency that would risk the public health, okay? And then they also go and say that a meeting may be held electronically by two two-way, and then a physical location is not required. So it really opens up just generally how it opens up, I think, from, you know, on a go-forward basis, Zoom meetings, which I think from a public policy perspective, so the reason that the Attorney General and the court originally said video conferencing and telephone conferencing, and by then they really meant, you know, maybe one person videoing in or two people, kind of the traditional way we've been doing it, because it actually encourages more participation. And I think what we've seen over the last 6 months is that, you guys may have seen this with your boards, I think the Zoom meeting is a way to definitely increase participation. There's people that, you know, might not want to, you know, drive a half an hour or go out in the cold to go to a board meeting, but they would certainly listen in on it, or, you know, make a public comment. So I think the policy behind it is also very much in compliance with the Open Meetings Act. So I don't know if anyone has specific questions about that in addition to that. But if this legislation passes, I think it's acceptable even without the legislation, but the legislation would definitely solidify it. There would be no question.
Right, right. And so I encourage all you guys to contact your legislators and let them know, you know, if you think it's a good idea. I think it's a very good idea. And I know for me, for sure, you know, sometimes just travel was hard. You know, when I was a director, I had elderly people on the board, and some of them just didn't want to come out, and that may have meant no quorum. And so, yeah, you know, if you don't meet every month, you know, you're really at the mercy there. So I really encourage you guys to contact your legislators and encourage that they support it as well. No questions in the chat so far. If anybody has questions, just to reiterate, if you want to throw something in chat. Okay, so the Library Privacy Act. So it's been recently updated, not completely through the legislature. Can you just kind of go over what changes it addressed?
Yeah, and I apologize. We're having some internet problems here. I pulled it up this morning, and then I just pulled up the Open Meetings Act, so I wanted to. I know many of you have heard about the efforts to amend the Library Privacy Act, and as Kate mentioned, it's not been approved by the legislature. I think it's still in the Senate, but we, you know, kind of hope and expect that it will be approved. There's a couple things that it does, and I'll explain the intent. The intent really was to be able to, one of the things that it does is it specifically exempts surveillance video from the definition of a library record. So one of the concerns that was, I think many of you have had this, I get calls all the time about this. You know, you have a crime in the library, or a crime occurs outside the library that's captured by your video surveillance. It's very frustrating for libraries and for police agencies to have to go through the process of getting search warrants in order, or subpoenas in order to obtain those. Because, you know, the Library Privacy Act was meant to protect what you read and what you look at from law enforcement, you know, from the invasion of law enforcement. You know, because you read a book on Al-Qaeda doesn't make you a terrorist, and you shouldn't have to be worried that people are going to come after you for what you're reading. The unintended consequence is that it also protects criminals who come to the library solely for the purpose of committing a crime, stealing, even if they don't come solely for the purpose, you know, for example, if, you know, their patrons using the library and gets in an altercation and there's an assault in the library. But I don't, you know, I personally don't think that that was what it's intended. And I want to be respectful, because I know that there are, you know, libraries out there that feel very strongly that we shouldn't make any amendments, and that you know, that the Library Privacy Act, anytime you make amendment to it, it's a slippery slope. So I want to acknowledge that's out there. But I think for me, from a practical purpose, libraries spend a lot of time and money and legal fees protecting criminals from, you know, even when the library is the victim of the crime. So the library record includes information about who the patrons are. And so this amendment excludes it. So it's not even a library record. It's not something that's private at all. Okay. But then it goes on to deal with it adds a section that allows the library to disclose without a court order records in a certain case. And it's kind of interesting because every once in a while I think, oh, we're doing this and is it really a problem? And one of them is when you have delinquent accounts, if you hire a third-party agency to collect fines or to collect materials, and you give them your patron list that says, hey, these people owe this money. Now, we've gotten around it because I take the position that typically that these companies are agents of the library for the purpose of collections. And my recommendation always is to have a provision in the contract that acknowledges that they're an agent for the purpose of the Library Privacy Act, and that third party should not, disclose or reveal that information. But it's always been a little bit touchy when those situations happen and there's no contract in place that specifies that. So it would specifically allow you to do that. It also, this is the interesting one that we added because it allows a library to disclose library records to another library or library cooperative for the purposes of conducting interlibrary loans. Because technically, as you know, you can't reveal patron information even to another library. I get this sometimes when, sometimes there might be a difficult patron that moves around among libraries. And the question always is, can I warn, library B that this person has been kicked out of library A and now might be in library B and this is what the person's done? And technically they can't. So technically under Library Privacy Act, you can't be sharing this information. So it seems ridiculous, and the likelihood anyone's going to cause trouble over it obviously is minimal because nobody has. But anyway, we wanted to make sure it was specifically included as something that you can do. This is the one that's also, I think, always been kind of an issue with crime in the library. And I'm going to read it to you so that you can see it and get a copy of the bill and take a look at it. It also does not prohibit an employee or agent of the library from providing a sworn statement or testimony to law enforcement based solely on personal knowledge of the employee regarding a crime alleged to have occurred at the library. So we go back and forth under the traditional Library Privacy Act principles is, can you talk to the police about something that happened at the library? And we have to go through the exercise. Well, do you know it because it's in a library record, or do you know it because you saw it? And I think this provision gives a little bit more protection and affirmatively states if you can tell police things that you saw at the library, and it gives you a little bit more protection. Now, if this is adopted, I would talk to your lawyer about this provision to kind of see where where we think the lines are as far as what you can say and what you can't say. But it is, I think, an improvement over the act. So, and then it does keep a violation of the Library Privacy Act, but if it only is if the employer agent knowingly violates the act. So I think it gives some greater protections for employees for violations of unintended if you accidentally do it or you don't realize it, the penalty is not there. You have to knowingly violate the act now to do so. So that would be kind of an interesting issue, about what your prior knowledge is before the release takes place. But that's it. And then there's a section that there's no statute of limitations right now if there was a inadvertent disclosure, and so now it has a 180-day statute of limitations if you accidentally released information last year and this bill was in effect, they couldn't bring a lawsuit even now. So those are sort of the main pieces of the proposed bill.
I think a couple important pieces to that too is education staff needs to be aware of, when and if this becomes, the new Library Privacy Act. Staff and board really need to understand all the implications, but law enforcement too. I feel like, especially in some of the smaller towns, they aren't aware of the Library Privacy Act and what that might mean, and why can't you just give me the name of the person? I want to look. Why can't you just do that? And So I think there needs to be some, some education on it as well. And, but it sounds to me like the interlibrary loan thing, I never even thought of that,
Well, it came up for me when I was talking to a client, and I was like, oh, and I've become more practical over the years, because the more years that go on, I've been doing this for 24 years, and the more years that go on and the more years that there's no lawsuit or no challenge, you kind of feel like the risk is, what's the risk? The risk is probably very small, but I think it deserves to be fixed. The one thing it might affect too, and if you have video surveillance cameras, you may want to start to think about what your policy is. There may be libraries that will choose to have it now because they think it's a protection. They can turn it over. They don't have to worry about library privacy issues. The flip side may also be true. You may have video surveillance, and you may feel very strongly about library privacy and don't feel like you would want to give that over without a warrant. The one thing that I want to point out too, that I didn't mention before, is that there's no requirement that you turn this over without a warrant. It's just permissive. That's the other thing, because we wanted to make sure that libraries wouldn't feel forced to disclose. It says you may disclose. It doesn't say you shall disclose. So you always, as the library, have the authority to say, you need to get a court order or subpoena. And that was important to us to put that in there, to give you the say as the library, and not like be at the that the police can come in and force that. So, but again, it still might affect whether you want to have surveillance or not.
So these changes came about because of something that maybe happened at a library, or it was just the whole point of having to get a search warrant for something that, it had nothing to do with the library record?
Yeah, I think it came about because of some frustration and about a situation in which there was a lot of thefts of, libraries are trying to do great things right now. So you guys are doing hotspots, you're doing laptops and Chromebooks, and you're loaning out very expensive things. So when someone, in this case, it was a bike, stole a bike, and we, the library then goes to the police. And oftentimes this is true. I found this my whole career, is that sometimes you work with law enforcement and they're great. They're understanding. They take the police report, they get the search warrant, they get the subpoena. But sometimes, especially police that are very overworked, are like, if you're not going to help me out, I'm not going to go through all this work. And so thousands of dollars of tax dollars are being lost on this. And I personally see, I would say most of the time, and it's not true for every library, so I don't want to generalize, but most of the time the library wants to give out the information because they don't like the public policy that you can commit a crime in the library and be protected. So a lot of times I have to be on the phone call with the police and with the library and explaining what we need, only so that we can all come to the same place, which is we want to voluntarily give you the information because we don't like that there was an assault at the library, or we don't like that, someone came into the library just to steal, high school students, Chromebooks. Okay. So, and I, as much as my business is, that's my business, I build time and all that, it really started to aggravate me that libraries were spending money on that, because it just seemed like everybody was on the same page fighting for the same thing, and that there was these roadblocks that, but like I said, there are libraries out there that feel very strongly about that, and will not be happy probably with these changes, and we want to be sensitive to that.
Absolutely. Okay, no questions in the chat. So, okay, contracted services. Do libraries have to provide RFPs or requests for proposal for all contracted services in order to get the best bid, or different, maybe better bids? I don't know.
No, the simple answer is no. There used to be a rule. There used to be, and I want to make sure that anything over $20,000 had to be bid out. And then as soon as that rule, this was like 20 years ago, as soon as that rule was introduced and passed in the legislature, it was inadvertently taken out of the law like several years later by another legislative amendment. So right now, there are certain types of projects that require bids, but they don't really affect libraries. Certain types of public works projects, for example, have required RFPs. So as a general matter, no. Sometimes the libraries have their own, and we do recommend having your own purchasing policy that would set up some limits. Even in the purchasing policies that I draft, I don't typically require RFPs or a specific number of bids, especially for libraries, because there's some services that you guys have that only are provided by a certain number of vendors, like Overdrive or something like that, where you might not have 3 or 4 qualified, bids. Now, things like, if you have a large plumbing job, for example, where you can send out some quotes, not even sealed bids or RFPs, but quotes, for example, even to get 3 quotes, just so that you're fulfilling your fiduciary obligation to spend the money in the best way. I always think that's the best thing to do. You can get into some troubles. I know years ago, a library got into trouble for purchasing property that they felt that the public felt was overpriced. And so sometimes not doing the homework about stuff like that might get you into hot water with your public, especially if you're asking for millages. But generally, no, I would have a purchasing policy so that you guys are on the same page. But, sometimes, depending on where you are, you might not have 3 accountants that, want to do, your work or something like that. So the short answer, I gave you a very long explanation, but the short answer is no.
Thank you. Okay, employment vacancies. Do libraries have to advertise if they have a position vacancy, or can they just, move from within? Or if they know, Mary's been a great patron here, and Mary's always talked about, I would love to work at the library. Is it fine just to hire Mary? I mean, you'd still have to go through the interview process, but do you actually have to advertise?
Yeah, and I know the answer to, so first of all, a caveat, I'm not a library lawyer and I don't pretend to be, or I'm sorry, I am a library lawyer. I'm not an employment lawyer. Sorry, I didn't mean to upset.
Wait, you are a library lawyer, wait a minute.
I am a library lawyer. I'm not an employment lawyer. And so I don't dabble in employment law, but having heard enough of the employment lawyers, I know that you don't have to advertise. If the director retires and leaves and the assistant director is qualified, I would have a conversation with your attorney before you did that, because there might be reasons for your particular library why you would want to advertise, even though you know that the clear front runner is your assistant director. So I think it's worth a call to your employment attorney just to say, look, the director is retiring. We want to hire the assistant director. We don't want to do anything. Do you see any pitfalls to that? Because I think if you have other people who have expressed an interest, for example, and you don't allow them, and let's say they're in a protected class, you might have some risks there. So I think it's one of those things that it's going to be a case-by-case situation, and it would be worth the time and the risks to talk to your attorney about your specific situation before you did that.
And so that was really the second one, is if the director retires or leaves.
Yep.
Yeah. Does the board have to go through the interview process to seek out other candidates? And
yeah, but there's no legal requirement. Like the law doesn't say you have to open it up for bids or you have to have an open process. I will do the caveat is I don't think, for certain positions, if you're unionized, that also might be a factor. So I'm assuming that there's not collective bargaining agreement that would govern it, but that's another factor if that is your case. But there may be good legal and risk management reasons of why you would want to open it up. And that's what you should talk to your employment attorney about.
Okay. And I saw this on the listserv, and I thought it was an interesting question. Is it appropriate to write a letter of support for someone who is running for political office when you are the library director in town? And I wanted to ask this person in what capacity are you writing this letter? Are you writing a letter as a resident of the community, or are you writing it in support as the library director? So could you speak to that a little bit?
Well, I think what you've raised is an interesting issue, because I think when it's your personal time, your personal opinion, we're not going to regulate that. But if you're signing it library director, there's a couple questions that I'd want to know. Well, first of all, I think that the Michigan Campaign Finance Act would come into effect, but typically it excludes policymaking officials. I don't know that there's been any case about library directors, so that might be an issue. I just generally recommend against using the library director, because you don't want to get a complaint, even if the complaint is baseless. The Michigan Elections Bureau can issue a complaint about a campaign violation, and it seems to me something that is a little bit risky. But again, this is one of those things where I would talk to the lawyer about what the risks are in the particular situation. Because obviously if you're doing it on your own time, even if you put your tagline library director. Also, I would think, this is just me personally knowing positions directors are in, but you might want to be a little concerned about some of your board members. Maybe they see that you've supported a candidate that they don't support, or that's a political party different from they are. And that shouldn't affect anything with your job, but you know how people are. And it would be something that I think I would take into consideration, even if it wasn't a basis for the decision. But I think all of that, it makes me, my first thought is I would stay away from that if I could. But if someone would convince me that there's a really good reason in a particular circumstance, I might say okay. But I'd have to know what the circumstance is.
Maybe it's her husband. I don't know, running.
Yeah. I don't think anyone would. I'd hope that they would support.
They would support, right?
I don't think there's anything like per se wrong with it. It's fraught with some issues, I think, that need to be.
Yeah, and I think sometimes it's just, if you have to think that much about it, or if it just doesn't feel 100% right, then maybe there is something, maybe you shouldn't, I don't know.
I think my hesitation really is just the climate that we're living in today.
Absolutely.
And, and I'm not telling people not to be, confident in their views on things and stuff, but you've seen it. Anyone who's on Facebook has seen just all the comments and the negative comments. And so I think anytime you take a political stance on anything, you're going to get people who are upset with you. And so so as the library director, with your name in your personal capacity, that's your right to do that. But, are you going to, if you're taking it as the library director, that criticism and stuff may come back on the library, even though you don't intend it to. So it's just another factor to consider. Again, not really a legal issue, but just a practical issue given the climate we're in right now.
So yesterday you did a patron policies webinar with MLA, and I found it very interesting because I know some of the things that you talked about, you made me look at things differently. One of the things was you were talking about hate speech, and you were talking about, how, when can you maybe ask somebody to leave? Maybe it's not so much hate speech at that point, but if there's a kerfuffle in the library and you want, somebody's getting very agitated and upset and they're getting loud, and maybe then they do throw in some racial slurs and things like that. And, you can't ask them to leave because of the racial slurs, but you can certainly ask them to leave because they are aggravating other patrons, or they're just being loud and causing a disruption. I just thought a lot of if you guys have a chance, go back and look at the MLA Connect from yesterday, because it was very informative, and also talked about the utilizing your meeting room. And if you do it for this group, you've got to be inclusive. You've got to do it for all. And if maybe somebody asked to put something, a display in the library lobby, that maybe, I think abortion was one of the examples yesterday, you know, say it's pro-abortion, you know, then you really need to have somebody anti-abortion there, as you have to have the opportunity to have both sides heard. Or you just say no, no public displays in the library to kind of skirt some of those things. But being inclusive in your policies was really important. And again, I think part of that goes to the climate that we're living in right now too, and the how at the drop of the hat it seems like some people are just, they just go off. And although not everybody's open, not everybody's library is open like they had been in the past, it is just something to think about. So if you get the chance, I would definitely suggest that you watch that webinar, because I thought it was very informative. So the EOs and the public health code. So this wasn't on the questions, not that I mean to spring this on you, but it's just very, Claire used a great term last week, squishy. It's squishy.
Yeah.
And you know, based on the emergency order from the DHHS, you know, masks are still required. Can you talk a little bit about maybe even the differences between the executive order and the emergency order?
Yeah, I don't know if everyone understands, because I think there's been a lot of misinformation about the Supreme Court decision too. Unfortunately, I think the governor is not correct in her assessment that it doesn't take effect for 21 days. And I don't know whether people have read things that contradict that. But what happened was there's a state court action that was started by the Republican Party in the legislature, okay? In a parallel, maybe not the right word, but there's also a court action. She was sued by people in the medical profession, okay, in the federal district court in Western Michigan, okay? So the state court case is still going on and hasn't been decided. But in order for the federal court to interpret Michigan law, they asked 2 questions of the Supreme Court about her authority. And that's what the Supreme Court ruled on. So the Supreme Court ruled on those 2 certified questions, and as you know from everything that you've read, struck down her authority to issue executive orders, I think after April 30th or whatever the date was. The federal district court has not entered an order that addresses those cases yet, and so we're still waiting on that to kind of figure out the full effect of it. I mean, the writing on the wall is certainly there. I think right now, I think that, you know, the Attorney General said she's not going to enforce it. I think I think sitting here today, unless the court's issued an order, I think they're still effective. But I think everyone's sort of taken the position that the Supreme Court's going to rule on the state case and it's going to be ineffective anyway. So, that's sort of what the state we're in. We're still in a little state of flux with the court decision. Okay, so what the response was is and I haven't looked today, so I don't know if there's any more, but at least Ingham County and Oakland County, their local health departments issued similar orders to the executive orders about masks and so forth. And then on Monday, the Department of Health and Human Services also issued their own order, which I understand. I was trying to find it before this meeting, but I was told that that maybe also have been challenged already by somebody. So we've got the local, if you're you might still have local health departments in your county that may issue orders to give you guys a little bit more clarity. Like many of the executive orders, this agency order is horribly written. It just is. It's very confusing. And Claire used the word squishy, and I'm going to use the word squishy and horribly written. But my takeaway on this is that you no longer have the occupancy restrictions that you had under the EOs. Okay. Um, I don't think there's the 6-foot rule for you anymore, but I do believe there's a mandatory mask rule in effect for libraries. So those are kind of the 3 areas that I see. One of the things that I might suggest is that you, in your plan, if you want to still require masks, which I think is probably the way to go, given until this, this agency order is challenged or otherwise challenged. But I think in your reopening policies, you can have, reference to this state, agency order, local health authority order, if you have that. But I also think that the library board has authority. There was a case, a case about, it was a barefoot patron case. And in that case, the library was enforcing a shoes policy, yet, no shirt, no shoes, no service issue. And I always remember this case because there's descriptions in there about what was found when they swabbed the library floor, and it's truly disgusting. So, I mean, think every bodily fluid you can think of was found at some place in the library. Just try not to dwell on it too much, but anyway, so they found that, and plus they thought it was a liability issue that, people could come in and cut their feet and, subject the library to tort issues. But it was a very, the test, they said it was a very content neutral. So it was a rationally based test based on the health and public health issues. So I do think there's authority for it. But like anything else, anybody who takes a stance on masks is getting sued right now. So, I feel very comfortable in defending any library with a mask policy under both the state order and under their own authority. But you know how people are these days. I've already heard a number of situations where people came in on Monday and probably yesterday and said they weren't going to wear masks. The EOs aren't in effect. And so there may be more challenges on that way, but I think using the executive order and the library's own authority, I think that is still required, because I know that many of you have staff that is concerned. And there's some question about whether, I'm not an employment lawyer, but whether the, OSHA and MyOSHA requirements require you to do that in order to safely protect your employees. I think to the extent that you still are, to the extent that that's something the library wants to do, I think, you should continue to enforce the mask requirement. Does anyone have questions on that in particular too? I just want to make sure.
Nothing in the chat so far.
Okay.
I just think that, I was talking to one of the directors who she's on the call this morning, talking to her last week, and these directors have so many things coming at them. I mean, they've got, what the board says, they have what MyOSHA says, CDC, WHO, Library Michigan, MLA, the EOs, now the health departments and the Department of Public Health. And you're just like, what do I listen to and who do I listen to? And you think these folks have been in so many meetings about all these things, and they have a little bit better understanding of it. Mm-hmm. And so, but the people who come into the library are just like what you had said, Anne, she struck, that's been struck down, so we don't have to do anything. And yet these poor library directors are just, what do I listen to? And then they're not only getting it from patrons, but sometimes staff. And
yeah.
And sometimes boards. And so it's really, really difficult. And squishy, I think, really is just my COVID word this year. I think that it just.
Yeah, and I will be joining the 2:00 call on Friday too.
Good.
Well, this will be, and I think we just have to take it on a day-by-day basis. And I know that, I mean, I don't like, even in my profession, I don't like uncomfortable nobody likes uncomfortable confrontations. And I think especially in a library setting where you're service oriented and you don't want to be getting into arguments with your patrons, and it's uncomfortable. And You know, people have been maybe not honest with their medical conditions because they don't want to wear the mask, and then are offended if you challenge it. It's just a terrible position to put libraries in. And frankly, there's something that, you know, we need to think about for some of the, you know, more northern communities and more rural communities, that you might have a lot more people that, you know, are not requiring masks in town. And so you might be the only person requiring masks in town now. So that's another factor I've heard. I don't know how much that applies to people in your cooperative.
So we do have a couple questions. Should we redo our PPE policy to reflect orders from the Michigan Department of Health and Human Services instead of the state executive orders?
Yes, I mean, and for those of you, I don't know how, the policies that we drafted in our firm, unless your board changed it, authorizes the director to make those changes. So that you can just simply, there's an exhibit to the policy to determine, you can just make those changes. You know, there was the ones that we did, I know that I had a little bullet point note out there that said you could either, because some libraries at the time, going back months, were saying, we're not going to require it unless the executive order requires it. So that's why there's a lot of those library reopening plans have the executive order references in there, because the libraries wanted the backing of the executive order. So if you don't have one of our policies and have something that you've developed, you'd have to take a look at whether you need board approval to do that.
And I would think too, some libraries had signage up that said, you know, masks are required based on executive order, blah, blah, blah.
Yeah.
So we probably just need to change that verbiage
Yeah.
as well.
I mean, I would maybe just change it to say, you know, masks are required based on, you know, state, local, and orders on the authority of the library board, something to that effect, so that you're covered in those.
Another question, are the MIOSHA rules based on the governor's EOs, or is that a totally separate thing?
It's a totally separate thing. MIOSHA has its own rules, and they're they protect workplace safety. I'm not that, I think Claire has a lot more. I'm going to give a shout out to Claire. Claire has a lot more in-depth knowledge into MIOSHA, because whenever I hear MIOSHA or OSHA, I kind of tune out and say, you need to talk to somebody else. So I know a little bit to be dangerous, but I think that's a question that if you're going to be on the call at 2:00, that MIOSHA questions can be, you know, fielded by Claire, or else I would have to get, you know, one of our, you know, labor and employment attorneys involved.
Gotcha.
But they are different.
Anybody have any other questions? Now's your time. Come on. We have Anne. Come on, if you have questions, Anne's here, you guys.
They're worried I'm going to give some long-winded answer again. Be like asleep at their desk. So I
am so grateful, because I feel like, you know, law is, well, obviously it's extremely confusing for the layperson, and the fact that we have had you and Claire to be able to define and distinguish different things for us along this road has been extremely helpful. I don't really know how we would have been able to decipher some of these things, or, you know, some libraries have attorneys, but they may not be as well versed in library law, and that's been the main focus for you guys too, and we certainly appreciate that. So
I think it's no secret that Claire and I have been, throughout this whole thing, Claire and I have been talking, because, you know, we want to make sure we're both, you know, we have kind of friendly arguments sometimes, and but a lot of times we're on the same page, and it's just nice to know that we're both, because I don't want to be giving out advice that, you know, is inconsistent with what she's saying without, you know, kind of figuring out if there's, you know, reasons for it. And right. She's so good at the research and the academic thinking part of it. It's been great.
Yeah, you guys are a good team. Should we be recording Zoom board meetings? If we do, are we required to post them somewhere?
You don't have to, you're not required to record them, and you're not required to post them. Okay, if you do record them, I would treat them the same as you would like an audio recording of a meeting, which is that the library's record retention policy approved by the state says they can be destroyed after the minutes of the meeting to which they refer are approved. be aware though that if you keep them or if a FOIA request comes in during that time, that it would be subject to FOIA. So that's just a consideration that, you know, wouldn't be pro or con. Some people like posting them and want to post them because they think, you know, just more transparency, but there's no requirement.
Sure. A couple more questions.
Okay.
So when a patron doesn't want to wear a mask because of the EO turnover, we can reference the health department. Because it's in our policy, we can give them alternative services or ask them to leave.
Mm-hmm. Well, this is, I feel like this is my most challenging question that I've got, and I get it from a number of libraries over the last, you know, several months. So it would be, what's the reason that they don't want to wear a mask? Okay. If the reason they state to you is that they don't think that there's authority to do so, I think that's an easier answer. I think that you ask them to wear the mask or you have to decline the service. You can offer them alternative service, you know, curbside or what have you. The more difficult question is when you have someone who says they can't medically tolerate the mask. That's a sort of a different issue because that puts you into a Americans with Disabilities Act analysis. And what that means is that you have to decide whether you can reasonably accommodate the disability. Now, libraries are handling that differently. A number of libraries take the position that if someone says they can't medically tolerate, they take the person at their word and they let them come in without the mask. You know, they might ask them to stay 6 feet from each other or you know, put up some other rules. The issue is going to be an issue of reasonable accommodation. So sort of but it's a case-by-case basis. So I've been asked several times to, you know, can you write a policy that tells us how we, you know, deal with this? And I can't because reasonable accommodation is particular to the person, what's reasonable to that person. And that's going to depend on the nature of their disability. And it's going to depend on, frankly, what services they're requesting from you. Okay. So, for example, you might suggest, and I've suggested that a lot of libraries have it, you might have like a face shield that they can use. It's under the EO, the face shield was not an acceptable mask, but now that the EO is gone, I think the face shield might be a more acceptable method. So that's one thing you could suggest, okay? Well, what if they decline that? Well, if they're just looking for a book or to pick up a book, you know, you can offer curbside service. And then if they decline that, the question is whether that was a reasonable accommodation. And if it was, you don't have to allow them to come into the library, okay? So reasonable is just that. Was it a reasonable accommodation? The person that has, and this is under any ADA analysis, you don't necessarily have the right to the accommodation you asked for. So just because you want to come in without a mask, if there's a reasonable accommodation that would allow the library to enforce the mask policy and still provide you service, then if it's reasonable, it's not going to be a violation of the ADA. Some things like computer use. If you have a computer lab and they have to come into the library to use the computer, obviously curbside service is not going to be a reasonable alternative. In that case, what you may do is set a computer up that's 6 feet away from people and allow that person to use the computer, you know, 6 feet away from people without a mask, you know, during that time. That might be the reasonable accommodation. So if you've got kind of a particular patron that keeps coming in and objecting, I mean, sometimes it's not, sometimes you have to do this on the spur of the moment. You don't have time to call your lawyer to figure out what the right thing to do is. But a lot of times it's just working it out with a patron. I think because the EOs have been struck down, and I've given you my reasons as to why I think the masks are still in play, but that's not going to prevent people from saying, oh, the EOs aren't in effect, I'm not going to wear them. So I think this is going to be more of an issue now than it was last week, frankly. So I would kind of work through how you think in your library this would play out.
That's a good question. I think that reasonable accommodation. I mean, if you tried. Okay, I have explained OMA and Zoom to my board, and they have decided to meet in person. As the director, I have a report to do. Can I require them to Zoom for me and the public who do not want to be there in person? Angela, do you want to unmute and maybe speak to that a little bit?
I think with their meetings, you, under this new, I don't know if this has changed. I don't know if this came up between the time the executive order.
I have a mic, okay.
I don't know if this came up between the time the executive order was struck down and the new, because we take the position that the new state order requires, it has that 10-person limit for indoor gatherings.
Okay.
And so what I say to you know, if you have a 7-member board and then your director's there, that's 8 people, then only 2 people, it's too risky under the Open Meetings Act to have a purely, you know, in-person meeting. Now, as the employer, can they require the director to appear in person? You know, that's something I think should be discussed with your particular lawyer, because that's going to be more of an employment related issue. I just don't see, I'm struggling because I don't see the reason why people are so adverse to the Zoom, but it's just happening. So I think I talked to your lawyer about that, because maybe a legal opinion saying that Zoom is still appropriate and the best option might be the way to go.
So there's one more question. How often do you hear about directors having nervous breakdowns midday?
More lately than in the past.
How about library attorneys having a breakdown?
Yeah, I've been trying to meet with Claire over the last 2 days, and everything keeps, I'm just like, for heaven's sake, stop striking stuff down and you know, it's a really, you know, it's a really tough time. It's a really tough time for people. People are on edge. They're cranky. They're quick to get emotional or angry. It's a really difficult time to be in public service. It's a difficult time to be an employee anywhere. It's just, people are, you know, and some people have their own really, you know, extreme thoughts on things. It's really difficult. So to the extent you can make through the, you know, midday without a nervous breakdown, I applaud everybody, because I've been there.
So I have,
but, you know.
I promised my people that there would be some giveaways. And so for 2 of the giveaways, I'm going to have, Anne, you pick a number. I need you to pick 2 numbers.
Okay.
One between 1 and 21. I need 2 numbers.
2 numbers between 1 and 21.
Yeah.
I'm going to go with 2 and 14.
Okay, 2 and 14. Okay, so number 2, this is the second person who signed up for this Zoom meeting, and that is Ruth Steele. And Ruth, you're going to get a $25 Amazon gift card. And then 14 was Jessica Little, and you're going to get a $25 Barnes & Noble gift card. And with that, I want to thank Anne for being here today. I do have some other giveaways that, Anne, you don't have to stay. You've given us an hour of your time, and we really appreciate that. So I want everybody else to stay, because we have a couple other things to give away. But the 2 biggies are right here. So if you don't want to stay, maybe not. I don't know.
Thank you guys for the great question and the opportunity to meet with you virtually. I always love talking to directors, so it's good to see all of you guys, even though we're not in person. So, and thanks, Kate, for the invite.
Thanks so much, Anne. Later. Have a good day. Bye-bye. Okay. So we've got a couple other giveaways, but you got to work for it. So a couple questions dealing with either White Pine or the Library of Michigan or libraries in general. So I'm going to ask you to put your answer in chat, so that way whoever answers first I can see, rather than everybody yelling it out, since I'm sure you're going to know these. Okay. Which White Pine member library is located the farthest away from our new office in Caro? And just guess, too. Closest guess, I'll give it to. Haven't hit it yet. Any other guesses? I guess I'll go with the one that was closest. So the farthest was Houghton Lake, 113 miles. Second was Iosco, so 104 and a half. So Bree, yay, Bree, you get this lovely cord organizer. Just what you wanted, right?